Imagine you've lived in the United States for years. You've built a life here. You've worked hard, paid taxes, raised your children on American soil, and then one morning you wake up and the rules that you thought protected your family, rules that have existed for over 150 years, are gone. Just like that. No warning, no grace period, just a new reality that millions of families were completely unprepared for. That moment is no longer hypothetical. It is happening right now. And if you are watching this without knowing exactly what to do next, you are already behind. Stay with me through this entire video because in the next several minutes, I'm going to walk you through exactly what changed, why it changed, who it affects, and most importantly, the specific steps every immigrant family in America needs to take right now before the window closes. This is not speculation. This is not political commentary. This is confirmed, verified information that could determine the future of your family's legal status in the United States. You do not want to miss a single word of what comes next. Welcome back to U.S. Entry Updates, the channel trusted by hundreds of thousands of immigrant families across America for clear, accurate, and timely immigration news. If this is your first time here, hit that subscribe button right now because the information we share on this channel is not available in a simple Google search. We go deeper, we go further, and today we are going Allen on the most significant immigration development in modern American history. Let's start with the foundation of what just changed, because to understand where we are going, you need to understand where we have been. For 157 years, the 14th Amendment to the United States Constitution guaranteed one of the most powerful legal protections in the world. It stated that any person born on American soil was automatically a citizen of the United States, no questions asked, no applications required. This principle, known as birthright citizenship, or by its legal term jus, solely meaning right of the soil, has been the cornerstone of American identity since 1868. It did not matter whether your parents were citizens, visa holders, green card holders, or undocumented. If you were born in America, you were American. Full stop. That era is now ending. Through a combination of executive action and accelerated legal proceedings, the policy framework around birthright citizenship has undergone a fundamental transformation heading into 2026. The executive order targeting birthright citizenship, which was initially challenged in federal courts, has now cleared significant legal hurdles. While the full constitutional battle is still evolving, the practical enforcement mechanisms are already being put in place. Federal agencies have begun implementing new documentation requirements. Hospital birth registration procedures are being updated, and crucially, the State Department has issued revised guidelines for how citizenship is determined at birth for children of non-citizen parents. This is not a future threat. The machinery is already moving, and the families who are most at risk are the ones who assume they have time to figure it out later. Now here is where it gets critically important. And this is the part that most news outlets are glossing over entirely. The change does not apply uniformly to everyone. There are layers, there are categories, and depending on your specific immigration status, the impact on your family could be dramatically different from your neighbor's situation. Let me break this down in a way that is clear and actionable. The first category is children born to parents where at least one parent is a U.S. citizen or a lawful permanent resident, a green card holder. For these families, the news is considerably less alarming. Under the new framework being enforced, citizenship at birth is still recognized for children in this category. If you or your spouse holds a green card or is a U.S. citizen, your child born in the United States after 2026 is still expected to receive citizenship. The critical word there is expected, because even in this category, documentation requirements have tightened significantly. You will need to prove your legal status at the time of the child's birth with a higher level of documentation than was previously required. Hospitals are being instructed to collect and report parental immigration status during birth registration. This is new. This is real. And if you are not prepared with the right documents at the time of delivery, it creates complications that can take months or even years to untangle legally. The second and far more vulnerable category involves children born to parents who are present in the United States on temporary visas, F1 student visas, H-1B work visas, B-1 and B-2 tourist and visitor visas, and other non-immigrant classifications. Here the change is seismic. Under the new policy being implemented, a child born in the United States to two parents who hold only temporary visa status will no longer automatically receive U.S. citizenship at birth. This represents a complete reversal of decades of established practice. Families who had planned around this possibility, parents who specifically arranged to give birth in the United States while on valid visas, are now facing a reality where that strategy no longer produces the result they anticipated. And then there is the third category, the one that carries the most urgency and the most fear. Children born to undocumented parents, or to parents where one parent is undocumented. The new enforcement framework here is the strictest. Citizenship is not automatically conferred, and the legal pathways to establishing citizenship for these children are currently being contested across multiple federal circuits. This uncertainty is dangerous. Children who are born in this window of legal ambiguity may face a documentation crisis as they grow older, a situation that can affect their ability to attend certain schools, access federal programs, apply for jobs, or eventually travel internationally. Here is the open question that nobody in mainstream media is fully answering yet. And this is where U.S. Entry Updates goes further than everyone else. What about children who were already born in the United States before these changes took effect? What is their status? The answer as of now is that retroactive application of this policy has been legally blocked. Children who were born as U.S. citizens before the enforcement date retain their citizenship. The changes apply prospectively, meaning going forward, not backward. But here is the danger in that reassurance. The documentation proving your child's citizenship, particularly if they were born near the transition period, becomes exponentially more important. Passports, birth certificates, social security records, the complete documentation chain for your child needs to be locked in, organized, and protected right now. Not next month, not when you get around to it. Now. Which brings us to the part of this video I most need you to pay attention to: the action steps. Concrete, specific, time-sensitive steps that every immigrant family in America needs to take based on where they fall in these categories. If you currently hold a green card or are a U.S. citizen with a non-citizen spouse, your first priority is to apply for or renew your naturalization if you have been eligible and have been delaying. The clock on that decision just became significantly more important. A naturalized citizen in the household changes the calculus for your entire family's future children under the new framework. If you have been sitting on an N-400 application, the time to file is not in 6 months. It is now. If you are in the United States on an H-1B, L-1, or Air-1 visa, and you are expecting a child or planning to have children in the near future, you need to consult with an immigration attorney immediately about your specific pathway. The intersection of your visa classification, your country of origin, your employer's role in your immigration case, and your timeline to permanent residency all factor into what happens with your child's citizenship status. There is no universal answer here. Your situation is specific, and generic advice from a social media post or a family friend is not sufficient for the decision you are facing. If you are on an F-1 student visa and you have given birth in the United States or are currently pregnant, the urgency is even higher. F-1 visa holders represent one of the largest groups affected by the new temporary visa provision. If your child was born before the enforcement date, secure their birth certificate and social security card immediately and apply for their U.S. passport as documented proof of their citizenship status. Do this even if you are not planning to travel internationally. A U.S. passport is the gold standard document for proving citizenship, and having it in hand before any further policy changes occur creates a legal shield that is very difficult to challenge. If you are undocumented or have mixed status family members, the conversation becomes more complex and more urgent. Simultaneously, there are legal organizations operating across the United States that specialize in exactly this situation. Organizations like RACES, the National Immigration Law Center, and the Immigration Advocates Network provide low-cost and sometimes free consultations for families in vulnerable immigration situations. Reaching out to them now before a crisis develops is infinitely more effective than reaching out after one. And if you have children who were born in the United States under the old framework, getting a passport in their name now is the single most important thing you can do to protect their status from future administrative challenges. Now, let me address something that a significant portion of the U.S. Entry Updates audience has been asking about the legal challenge landscape, because this story is not over. The Birthright Citizenship Executive Order and the implementation policies have generated an enormous volume of federal litigation. Multiple circuit courts have issued conflicting rulings. The Supreme Court has been signaled that this issue will likely come before it and that legal uncertainty cuts both ways. Yes, it means there is a chance that portions of this policy get overturned or modified, but it also means that families who are waiting to see how the lawsuits turn out before taking any action are making an extraordinarily risky bet. Courts move slowly, policy implementation moves quickly, and the families who prepared, regardless of the legal outcome, will be in a far stronger position than those who are waiting for a court to save them. There is also an international dimension to this that almost nobody is discussing, and it matters enormously for families with ties to other countries. If your child is born in the United States after the policy takes full effect and they do not receive automatic U.S. citizenship, their citizenship status depends entirely on the laws of their parents' home countries. Some countries grant citizenship based on parentage. This is called jus sanguinis, or right of blood. If your home country has this system, your child may still be a citizen of that country from birth. But here's the complication. Not all countries recognize dual citizenship or citizenship by descent through both parents equally. Some countries have gender-based restrictions on citizenship transmission. Some require registration at a consulate within a certain period after birth, or the child loses their eligibility for citizenship by descent. If you are a non-citizen in the United States and you are expecting a child, you need to contact your home country's consulate now to understand exactly what their citizenship laws require and what timelines you are working with. This is not an administrative nicety. This is about making sure your child has a country legally from the moment they are born. Let me give you a real-world scenario to illustrate why all of this matters so concretely. Consider a family, both parents from India on H-1B visas, living in Texas, expecting their first child in late 2026. Under the old rule, their child would be born a U.S. citizen, period. Under the new framework, that child's citizenship is not automatic. The parents are on temporary visas. Under the new policy guidance, the child would not receive automatic citizenship. The parents are in the middle of a long backlogged green card process, common for Indian nationals, due to per-country caps, and their priority date is still years away. Meanwhile, India grants citizenship by descent but requires consular registration within a specific window. If this family is not aware of these requirements and misses the registration window with the Indian consulate, their child could be in a genuinely precarious legal position, not automatically American under the new rules, and not registered as Indian because the parents assumed the American system would handle it. That scenario is playing out for real families right now. And the difference between the families who navigate it safely and the ones who face a crisis is almost always the same thing: information and preparation. And one more thing before we close, and this one is important. There is a wave of misinformation moving through immigrant communities right now about this topic. People are sharing outdated information, incorrect legal interpretations, and in some cases, outright false claims about what the new policies do and do not cover. Some of that misinformation is innocent, people sharing what they think they understood. Some of it is less innocent, coming from individuals looking to profit from fear by selling legal services that are not necessary, or worse, scamming families out of money for filings that do not exist. If someone is telling you that you need to pay them urgently to protect your child's citizenship through some special filing process that you have never heard of before, that is a red flag. Real immigration attorneys do not operate through panic and urgency. They operate through consultation, documentation, and process. The U.S. Entry Updates channel exists precisely to cut through that noise and give you verified, trustworthy information so you can make informed decisions, not fear-driven ones. Here is where we stand. Birthright citizenship, as it has existed since 1868, is undergoing its most significant transformation in American history. The policy changes are real. They are in motion, and they have different implications for different categories of families. Children of citizens and green card holders remain protected, but with tighter documentation requirements. Children of temporary visa holders face new uncertainty and risk. Children of undocumented parents face the highest level of vulnerability. And all families, regardless of status, need to be proactive right now about documentation, legal consultation, and understanding their specific situation rather than relying on general assumptions. The families who will come through this transition with their status protected and their future secure are not necessarily the ones with the most money or the most powerful lawyers. They are the ones who got informed early, took the right steps in the right order, and did not wait for someone else to solve this for them. That is exactly why this channel exists and exactly why you are here. If this video helped you understand something that you did not fully understand before, please take 2 seconds and hit that like button. It costs you nothing, and it helps this information reach the families who need it most. Share this video with anyone in your family, your community, or your social network who has children or is expecting children and is living in the United States on any immigration status. This is the kind of information that changes outcomes. And subscribe to U.S. Entry Updates if you have not already, because we are going to continue covering every development in this story as it unfolds. The court decisions, the new agency guidelines, the consular updates, and the practical action steps you need to stay ahead of every change. The rules of American citizenship just changed. The families who know that and act on it will be okay.